The world turns, and with each turn, a change. And each change makes it more complex, unpredictable, enigmatic. The world keeps turning. And from the Pellicer and Heredia practice, we anticipate everything that is going to happen. Brexit, artificial intelligence, new commercial borders, legal tech. The world keeps turning, and it commands the reliance on international lawyers who are capable of interpreting this new reality with integrity, honesty, and transparency, offering answers to so many new questions. Whatever it is, ask us. At Pellicer and Heredia, we know how.
Good afternoon, everyone. Thank you for joining us today. Today, we're going to talk about the importance of doing wills in Spain, the probate, and the importance of doing tax planning. Okay, I've got the pleasure to have here Michael Davies from Almeria, Andalusia. Hello, Michael.
Hello, Ignacio. Hello, everyone. Good afternoon.
Michael is a very good, reputable lawyer. Had a lot of expertise on inheritance from 25 years already. And he's the ex-honorary consul in Almeria, and I'm delighted to share the knowledge today with him and to exchange information for all of you. We have on the other side, Pedro. He's driving from the Heredia office, and I think he's in a traffic jam, so he's going to join us now. And we're going to start talking about wills. Before I go, I will be grateful if you could send us all your questions on the panel. On the chat, there is a chat there. And if you could please send us all your questions. We've got 1 hour to do and run through questions and answers. So a lot of you, I will start saying, a lot of you ask me, Ignacio, is it really worth it to make a will in Spain? And the answer definitely is yes, as long as you've got assets in Spain. Some of you might have only money in the bank or just a vehicle, which probably some of you say is not really worth it. I still consider that is very good and very important because it's your instructions to the executor and everyone to say who's the beneficiaries of your will. Okay, so that's very, very important, and always encourage people to do it. As well, you have the possibility to do, if you have international assets, to do different wills in your home country, like could be the UK, the United States, different countries. And you could just even limit it to the assets over there and just have a Spanish will. Alternatively, you could do still an international will that covers Spain and worldwide assets, but it's important for you to discuss it with the lawyer that you deal with to see how easy it is to execute that will. A lot of questions I had as well about taxation. Taxation is important, and later on, Michael will tell us how efficient could be doing tax planning in one community or the other one. Okay, so then on number 3, we're going to talk about endurable power of attorney, because I'm sure a lot of you may questions about how good is to make, how good is easy and how good is the tool of a power of attorney, which I consider very good depending on certain age, if you're planning to go abroad, etc., etc., etc. Okay, so the tips of advice I will tell you today, if you don't have a will, then I will highly recommend you to listen in depth. And even if you do have it, my experience, and I will share this with Michael later on, my experience, try to make it simple and discuss it in advance. On one side, always try to do the tax planning, use the allowances that the law allows you to use today. And on the other hand, try to have ahead a plan when the inevitable happens, how you want us as an executor, or your lawyer as an executor, or your family member as an executor to do things. Okay, very, very important. Okay, We're going to just start now, Michael. I would like you just to give just a little tips, Michael, from your experience in the past. You've been dealing with a lot of inheritance cases. And if you could give us 1 or 2 minutes of your expertise, what kind of recommendations, to start with, Michael, you will tell people who made a will, who pay people who didn't make a will and they're considering to do so. So, Michael, over to you.
Okay, thank you. For those that don't know me, my name is Michael Davies. I'm a Spanish lawyer. I practice down in Andalusia. Ignacio, as most of you will know, is up in the Valencia region. We're down here. Okay, I have been handling probate for over 25 years. We've handled hundreds of probate cases, and from that experience, there's a few tips I could provide you with. Number one, without any doubt, if you have assets in Spain, you should make a Spanish will. Now, most people nowadays, most expats do actually get around to doing Spanish wills, but we're still finding, even though it sounds incredible enough, maybe you have the odd one as well, we're still finding the odd case of people that somehow have fallen through the net and have never made a Spanish will. It's much more complicated to wind up the estate and much more expensive. Regarding making a will, if you go and see a solicitor in your area that knows what they're doing, they're going to be advise you to make sure that the probate can be dealt with quickly. In Spain, if the will is in good and normal order, you can get probate and wind everything up and be ready to sell the assets within 3 to 4 months is what we normally tell our clients. You'll probably find that the inheritance tax is much more beneficial than what you may have suspected. Inheritance tax is completely different depending on in what region of Spain you are. So you'd have to make sure, and this is something that creates a lot of confusion, Ignacio, is when people Google about inheritance tax, they get very confused. We've got 17 different systems in Spain. So you've got to work out in which one you are. And the advice that your solicitor will give you regarding how you distribute your estate will be different to make the maximum use of the exemptions that are different in each region. The other thing that I'd advise, that's the first thing, to make a will. And the other thing I'd make sure is that if you have already made a Spanish will, make sure it complies with what's called Directive 650/2012. That was a law passed by the EU in 2012 and came into life in 2015 that's causing a lot of nasty surprises. Basically, if you are a resident in Spain, you must make a will in Spain stating that you choose your English law to determine how you are allowed to distribute your estate. If you don't do that, they will apply the system of obligatory heirs that exists in Spain, that basically means that 2/3 of your estate have to go down towards your children and not across to your spouse, which is what you may want. So if you have done a will before 2015 and definitely before 2012, definitely go back to the solicitor that made the will for you and ask them whether it complies with Directive 650/2012, because perhaps, almost for certain, you may need to review that will and change it. Those are the two main things. Make sure you make a will, and if you've already made a will, make sure it complies with Directive 650/2012. That's where all the problems are: people not making wills and people that have wills that are non-compliant with Directive.
Okay, thank you, Michael. Before we just jump straight into questions and answers, I'm sure, Michael, I don't know whether you could share the questions that you have from Andalusia, copy and pasting here on the chat, the ones that you probably think are quite relevant. I would like to ask Pedro here about, from his expertise, what does he recommend from the probate he's been dealing with and from the wills he has signed, which are obviously hundreds, I suppose. From all this experience, Pedro, is it worth it to make a will in Spain? And if not, what kind of problems you've seen? Over to you, Pedro.
Well, hola, Michael. Hola, Ignacio. Buenas tardes. Good afternoon, everyone. Okay, well, regarding the wills, this is something that we've been saying many times in order to prevent the possible troubles or problems in order to they may happen in an inheritance. Okay, and well, we need to divide into the why it is important to make estate planning and what is the vehicle to do that. And as I think it's been said by Michael, I just listed the latest points, but obviously it's a recommendation to make a will. At the end, the will is I think it's a must. It's something important. It's personal. It's a secret. Obviously, you can do it as many times as you want. Obviously, will count just the last will, and is in order to organize really which are going to be the beneficiaries. Okay, for those who are not Spanish and live in Spain, who are residents in Spain, I would say, even though I recommend it to everyone which is Spanish and resident in Spain, I think it's almost, I would say it's not an obligation, but it's like, for me, it's like an obligation. Well, for someone who is a foreigner, not national Spanish, and living in Spain as a resident, I would say it's a must. Why? I assume that Michael has said that regarding this European law that we have, that unless you do not choose your national law, there will be a Spanish law to be applied. And I just want to remember what is Spanish law regarding inheritance in order to everyone to know if agree or not, and if don't agree, do rapidly a will in case that you are I mean, if you make a will, it's a document that will substitute really like a probate, or will substitute like a declaration of heirs in the future. So will you planify? Spanish law, what it says really is that the descendants are the parties which is going to be receiving the assets. If there is no will, if there is a will, can be as a limit, minimum limit is at 2/3 of the assets. We call it legítima tercio de mejora, which is inside the heirs, the obligationary heirs. So 1/3 for heirs, legítima forzos, as it is in Spanish. And then 1/3 is another third is a mejora. You can add or give more values to some children instead of others, as descendants. So descendants are the key point on the Spanish law, descendants. And then you have 1/3 as a free disposal. You have a freedom to give 1/3 of your assets to anyone who you may choose. Also, there is an obligation to give 1/3 as a minimum, 1/3 of a joint of the assets to the spouse which is alive. This is Spanish law. So in order to avoid and be able to give, for example, your assets to your wife or your assets to your husband or to a friend or whoever you want, in order to have freedom, according to some laws in Europe, let me point the UK law is one of the, I would say, that has a lot of freedom in order to choose beneficiaries. You need to make a will and state that your national law will be binding and will be applied in your inheritance in order to choose the beneficiaries in order to avoid the Spanish law. For example, I'm married, I have 2 children, I cannot avoid Spanish law. I have to, I make a will, I've made a will, and I can give 1/3 of my assets to my spouse, and my children will be the most beneficiaries, but I can organize that in some way. So a will, in order to answer you, Ignacio, a will is, I would say, is something totally recommended for Spanish, totally recommended if you are foreigner living in Spain as a resident. And I will also add, even if you are not resident and you have made some investment, I also recommend it in order to eliminate any complexity on the possibility in the future to if the inheritance is coming in, for example, in a different country, in order to avoid misunderstandings, interpretations, in order to state that the assets that are in Spain, for example, in the territory of Spain, will be given to the beneficiaries that you have chosen in the will. So it's totally 100% recommended to make a will, Ignacio.
Okay. Thank you very much, Pedro. On top of that, I will just to remind people that they could, when they do the will, and if we go to the notary, we could organize what we call testamento vital, or what will be like a living will, what we purely translated, is only for social security purposes. You could still make a different will, which is connected to the social security, to basically say what you would like to do with your body, how would you like to be treated as well. On the other hand, you could even mention in the will about the applicable law. I think it's called, well, in Spanish it's euthanasia, and I think is in English, Michael, I think will be euthanasia. I don't know for sure.
Sorry?
The euthanasia in English, I wouldn't.
Euthanasia.
Yeah,
euthanasia.
The same, pretty much. And that's being approved, and you could even add as well, even if necessary, in that will, on the will for Social Security. Okay, that's something that you could leave it here. Now, we're going to just go to questions and answers. I think David did ask questions about tax planning here on inheritance, but we're going to jump first with one question from Sandra that says, hi, I own a house with my brother and deceased sister. We have a third each. My sister only made an English will where she left her estate between my brother and myself. My sister was not married and had no children at the time of her death. The property is in Cartagena, Murcia. Our father is the only other next of kin. Who should my sister's share go to? Michael, would you like to say something here?
Yes. So he's saying that his sister has passed away and she'd made an English will, yes?
Yes.
Leaving everything to her two brothers, to her brother and sister, yes?
Yes.
Okay. An English will. I'm going to presume that she was non-resident because it was only an English will and things, and the property was in joint name, so probably a non-resident. Well, what's going to happen is that there's no Spanish will, so that will need to be proved that there's no Spanish will by the Central Register. Once that's been proved, we would have to wait until she goes to probate in the UK on that English will, until probate's obtained. When probate has been obtained, there's going to be no other solution but to convalidate that the result of probate and will and use that in Spain. She's named the two beneficiaries. There's no children. There's no problems of obligatory heirs. So in the end, the two people named on the will in the UK will be the beneficiaries in Spain. So the only trouble that it's going to take longer and it's going to be more expensive to the probate procedure because of the convalidation. But there's no other complications. So instead of taking 4 months, it may take them 6 or 7. And then as far as inheritance tax, brothers and sisters in Murcia area have only got an allowance of €8,000, so there'll be some inheritance tax to be paid as well. And that's
it is important, Michael, to mention the time frame for them to do the tax.
Yes, they have to get tax clearance within 6 months. What I would recommend in this case, because they're going to have to convalidate the will and probate from the UK, they should request an extension. Within the first 5 months, you can request an extension, which in this case, as there's no Spanish will, it would definitely be granted. So in total, they'll have 12 months to wind everything up, which is a sufficient time.
Okay. Good. Pedro, would you like to add anything with regards to the question?
No, I fully agree with what has been said. Yeah, I fully agree with what's been said. Obviously, if in case that she would be resident, then things change. I mean, and then Spanish law applies. If there is no will, or nothing has been said.
Pedro, if the will,
I'm not sure if he says.
Pedro, Sorry, Pedro. If the will in the UK is to cover worldwide assets.
Yeah. Obviously, yes.
Assets.
So there is a will in the UK.
When we can validate it. Yeah, so then there's no need to make the motion law. Yeah.
Okay. Yeah. If there is a will in the UK, I understood it was no will. So if there is a will in the UK, I fully agree with what has been said. Yeah.
There is no will in Spain, no, and there is one will in the UK.
There's a worldwide assets at the end is make a probate is like nothing that there is in the UK, and that will be covered in that. Yeah, absolutely.
Okay.
But I mean, I insist on. If he were resident, European law is attracted as a resident.
Right.
It says here, made a will in the UK.
Yeah, they did. They did make a will. Daryl is asking a question here, guys. If my wife and I are on title of our house and I die, does it go all to her, or does part of it goes to our children before my wife dies? Michael, would you like to just jump onto it? Because there is some question you need
Yes,
to ask
of
for
course.
Daryl.
Well, if she's made a will choosing English law to determine how she wants to distribute her estate, and on the will they leave everything to each other, well, then there'll be no problem whatsoever. They will the property will go from one to the other. If, on the other hand, they are residents of Spain and have not made a will, then if one of them passes away, Spanish intestate procedure is what will be used, and 2/3 of her part would go directly down to the children. So, of course, if they were minors, that will cause a problem if they need to sell, the surviving spouse needed to sell or something like that. The solution is, as Pedro says before, is to make a Spanish will in which you choose English law to determine how you're going to distribute your estate, and then go on from there to leave everything to each other, for example, and then down to the kids. And then there'll be no problems.
Right. Okay. Pedro, would you like to add anything else?
Oh, anything else? It's fantastic. Yeah,
okay.
Good.
Right. Let's move forward. Then we have here the directive. If Michael or Pedro, would you like to type the directive they're asking? I think I think 15/2012.
I will write it down.
If you want to write it down in the chat. So what directive? But basically, that directive, Guy, it says here, very simple. If you're a national of a different country, you've got the option to choose your personal law. And this is linked to the question that Carol from Australia is asking here. Well, I don't know if it's Carol. I think, no, it's Antoniette. Antoniette is asking in the chat here whether it could be covered by Australian law, right? And what the directive says here, Guy, is very simple. If you are of a different nationality, you can use that personal law. So that directive, it was signed by Spain. So don't get confused saying UK did not sign that treaty, that directive, that convention, or the other country. No, it's something that if you applies to residents in Spain. So the first requirement, that directive, if you're a resident in Spain, then that's binding. Then it says, if you didn't say anything at all, let's say you didn't make a will, then the applicable law will be the law of your residency, which is Spanish law. And that's exactly as Pedro stated with the force as. Now, if by any reason you did make a will, I'm sure, or probably you were advised to pick the right law or the one that you want to use, which is only, you've got the option to use the personal law on one side or the residency law of the country where you live, which is here, in this case, is Spain. Now, all the countries in Europe did sign this directive, but Spain did sign it. So it's very good, as Pedro stated before, because as Spaniards, we are not allowed to use, because we're Spanish nationals and we have no option. But if you are American, you're British, you're Australian, you're from a different country, you've got the option to use that law or just to use the Spanish law. It is very important to do first the planning of how the law allows you to distribute all your assets. Secondly, the allowances that we could talk into it now about the tax planning. And number three, the applicable, the distribution of assets, you see. So on one side, what applicable law we could use, Spanish, American, British, Australian, okay. Second, what kind of taxes we're talking about? How can we split it? How can I do beneficiaries? Three, is it useful to have an executor? Yes or no? What can they do for me? And the five, the distribution of assets. Okay, so I think it's really worth it. We are actually, me personally here in the office, we're dealing with a case which they did split it between a lot of people. Unfortunately, there are children, grandchildren, and there are 9 heirs. And you can imagine the complications of putting everybody together. Even organizing power of attorney for us to represent is making it complex. So I normally recommend trying to make things simple, because the simpler the better. But sometimes it's not possible. And then you need to bear in mind that in the future, we'll be dealing with all international documents. So the first thing the beneficiary will do is will grant power of attorney to solicitors or the executor to represent. And that's something, I don't know if Michael did experiment recently, that sometimes we could get stuck only organizing that, Michael. We're talking about power of attorney. So you think?
Yes, people involved, the more complex. Sometimes there's a trade-off between reducing inheritance tax by dividing up the estate more and the actual, how complicated it ends up, the actual estate ends up coming. In the old days, now in Andalusia, we have €1 million exemption between spouse and also for each child. So we don't normally have to play around too much to avoid the inheritance tax because most people don't pay it. But in the old days, when we had a lower exemption rate, we often tried to divide up the estate as much as possible between grandchildren, children, to claim as many exemptions as possible. But of course, all that now in Andalusia is not necessary. And that did cause obviously problems with powers of attorney, the sheer numbers and the expense of the probate procedure versus what you're saving in inheritance tax.
Michael, speaking about the inheritance tax, Carol, she just sent us a text here saying, could you please explain how inheritance tax works? We are non-Spanish resident, will make choosing English law, living property to spouse. Could you roughly give them an idea how it works generally? We don't know where she lives though. Michael,
okay, it doesn't matter for the explanation. Okay, the first thing is people get very confused. When we say that you choose your national law, which you can choose your national law, it's only to the extent of you determining who you can leave your estate to. The choice of national law has no effect on where you pay your inheritance tax. Okay, there's no choice regarding that at all. If you are a non-resident, the beneficiary has to declare any assets that they receive in Spain. Now, if they are non-residents, the level of inheritance tax that they pay will depend on the region, on where the maximum connection to the estate is. So, for example, if she's receiving from her spouse, if she lived in Andalusia, up to €1 million, it would be exempt. If it was in the Valencia region, the first €100,000 would be exempt. It depends on where the estate is. Okay, if you are a resident, you claim the exemptions of where you are a resident. If you are a non-resident, you claim the exemptions of where the maximum connection to the estate is. In other words, where the maximum value of what you're receiving is. Say we've got one general system, and then each region of Spain, and there are 17 of them, have created their own exemptions. So you've got to determine which exemptions you're entitled to. And it depends on where the assets are.
Okay. Thank you, Michael. We've got Bill Owens. Hello, Bill. Nice that you are joining us today. He's asking today, besides euthanasia, can you include a healthcare directive in the will? The directive would direct doctors not to resuscitate or use any life-saving measures if it is determined that a spouse would be in a vegetative state or diagnosed brain dead. Yes. So, Bill, the answer is yes. Before euthanasia, the vital will, which is one, as I said, one is about the asset, civil, and the other one is about the social security or health, right? In that one, we did sign a few, several ones actually, specifically saying that, Bill, saying that, yes, you don't want to keep alive on the artificial way, basically. I think, Michael, in Andalusia, probably you've done the same, yes?
Well, we have that option, but in Andalusia, we have a second option. And that is that anyone's allowed to go into a hospital in Andalusia and go to the information desk and you ask, and there's a form that you can fill in where you can do that without going to the notary, and that goes on their database. And theoretically, and I say theoretically, the moment you sign that, it's available to all the hospitals in Andalusia what you've signed regarding the living will. The advantage is for free. The disadvantage that you depend on their system working correctly. Our clients, most of them, still opt for doing the one at the notary, like the one that you're suggesting in the Valencia region. Yeah. It's just that sometimes we have clients come back to us and say, well, we could have done this for free at the hospital. It's true. It's just that the one, if you sign it at the notary, you've got the document in your hand. So it's just sort of a different way of doing it.
That's correct. And that's exactly here the same, Michael. You could do it in Social Security or here. But what we're trying to do here, when clients are asking to do it, we're doing two in a row. So we do the civil, which is about the assets, and then we sign at the same time, just to keep it on records, because the notary will send the details, and as you said, to the Social Security, and hopefully will be more efficient rather than popping in.
And the family will have the document in their hand, so that if you go to hospital, they can actually, if nobody can find the database or whatever, they can actually show the doctor, look, these are my, you know, my spouse's wishes, or you know, my children's wishes, or parents, or whatever.
Okay, right. Let's move on then. Pedro, would you like to comment any other question here from the panel, or will you prefer
I'm just reading from I'm reading from the very first beginning, and it's regarding trust.
Yes.
As trust, and this is legal institutions in this case in the UK or in Anglo-Saxon law, which is not recognized in Spain. It is not recognized in Spain. There's a convention about that in Hague Convention 1985, where Spain didn't agree. Just to simplify about the trust in Spain, and connecting also with the inheritance and gift tax, understands the tax official in Spain understands that the creation of a trust constitutes an increase in assets for those who are beneficiary, like for profit. It's like, so inheritance tax accrues at the time of the creation of a trust, except if it is a discretionary trust. And it seems that it happens in many occasions, but needs to be checked and studied and reported. So if it's a discretionary trust, well, may have the option that the inheritance tax do not start at the beginning, and is in some way whenever the beneficiaries receive really the assets. There are some resolutions about that. I can name one if it's in May 2014. But these things about trust, and I'm sure that Michael has more experience than myself, but regarding that is something that is before you do it or before you understand something, please report to a specialized firm, as we can do that, Michael can do that, in order to be sure whether this trust will be, the inheritance will be from the start or from whenever the beneficiaries or the trustees receive the assets. But it's not, it is an institution, it's a legal institution, but it's not recognized in Spain, okay? That is
Okay, I'm going to give some very straightforward advice about trusts. I've seen lots and lots of trusts over the years, and my advice is, in Spain, you've got to avoid relying on a trust to wind up a state like the plague, literally. For those clients that have been unfortunate, they haven't got a Spanish will, they've made a will in the UK, and we've got to then rely on that to be convalidated, and they set up a trust, etc. When we come to convalidate that for use in Spain, it results in a nightmare on all fronts. And the nightmare can go from something that simply results very, very expensive to a situation that can never be resolved. It can be as bad as that. So with the trusts, there are all sorts of problems. And I'll read out a question that we had about trust, because it's quite funny. Regarding the trusts, it can even trust in Spain, the closest thing to trust in Spain is what's called the Sociedad Fideicomisaria, which isn't exactly the same.
Exactly.
When the trust is discretionary, as you just mentioned, Pedro, discretion in the sense that the settlers can actually sell assets and distribute the assets in different ways to, an equal distribution or whatever. When you have situations like that, we've had the tax man tell us that they don't care at the end who the trust says is the beneficiary, because that solicitor, who's the settler, can actually, at his discretion, sell assets, move them around, etc. They're going to consider him the beneficiary because he's got access to all the funds, all the things, and they don't. How can they say that the beneficiary is the child and allow him to have all the exemptions as the child when in fact the trust doesn't necessarily have to hand all those funds to that person at the end of the day? It creates all sorts of problems. I've spoken about this on other webinars, and I've got an email today with someone who must have seen one of these webinars, and this is the email. It says, to the attention of 𝐏𝐞𝐥𝐥𝐢𝐜𝐞 Michael Davies, inheritance webinar. So he says that he doesn't believe this, and he wants to put it all to the panel. His situation is, I would like my 3 grandchildren to benefit from my estate. So I have set up a discretionary assets if my children needed the funds before it was, before the grandchildren are grown up. I've spoken to a solicitor in Spain and says that he will not mirror that will in Spain and do the same will things. It will cause too many problems. Now I've read on your blog that this is a disaster. I'd really like clarification of this. Well, that is the clarification is that the solicitors told him not to make the same will in Spain mentioning a trust, because of course he can go ahead and do it, but then it'll be a nightmare. If he doesn't do one and relies on the English one, he's going to have the same problems. So he's got to find a way of dealing with his Spanish assets to try and get as close as possible to what he wants, maybe the use of life possessions or whatever, but he must not use the trust. I need you both to back me up now so he doesn't call me 𝐏𝐞𝐥𝐥𝐢𝐜. So, I think I know more than anyone.
And Michael,
right,
let me just mention an email that I reported to my client, just to complete what you're saying. Is like, I told him basically there is no tax criteria by the General Office of Tax, like tax office, General Office, through binding consultations, like a resolution, which is like law, to differentiate, to make the difference between the existence of discretionary and irrevocable trust, in which case we are at the time of death of the settler. So therefore the conclusion is that there is no tax certainty about how the administration could tax your wife or the income from the trust. Even so, insist on having a study on report about the trust that you're having as a discretionary or revocable, in order to verify what criteria may be taken by tax office. But tax office, there is no criteria. So it could happen anything really. So this is important to study that before or avoid it, because it's not recognized in Spain.
It's a big mess because, for example, there's a lot of complication between the property register. Let's say there's a property involved, okay? And they name 2 trustees, 2 solicitors in the UK, some grandchildren who are thing. So we're asking the registrar to register the property in the name of the solicitor so that it can be sold. And the taxman is saying, you're saying that this asset goes to the beneficiaries, who are the children, and you're claiming the exemptions because it's going to the children. And yet you're asking me to give you tax clearance that will allow you then to register the property in the name of the trustees who could sell the property, and because it's discretionary, hand the money to somebody else. And then you've avoided inheritance tax, and you can end up in this absolute mess where you can't move forward.
Okay, let's move on then, you guys here, because time is running out, and then we have lots and lots of questions. Right, something that Maria is asking, and she says she obviously recommends drawing a will in Spain. Her situation has to do with an inheritance of a property in Spain by a minor and her mother because of death of the father. I think it says here, because of their father. Yes, there was no will. Now, child and mother live in the UK. Inheritance paperwork has been taken care of in Spain. The issue is selling the house in Spain on child behalf, living in the UK for past 11 years. Spanish authorities say we need legal authorization from where the child lives. UK authorities need clear explanation of what is needed in Spain, which I'm told UK should buy Spain, UK should, I don't know what she says here, which I'm told, right.
Matthew, where is this question? I can't see it. Where
it's
is it?
524, it's 524, the one. 524. Okay, right, before even we go into further details here, I agree with Maria. Yes, it's two things I will highly recommend you here from my experience, and I'm sure Pedro and Michael will have their say here. One is to make a will if you want to have full control, or as much as you can, from all the assets you have in the world and in Spain. That's number one. So that basically will be your instructions following the law. And then the second thing, which I found problems, and you should be aware here, is if you're going to leave it to grandchildren, children that are not legal age, we're going to have an issue here. In most of our wills, you name us as executors, and if something happens, then we have the issue of putting everything into the minor's name. The situation is, as Maria says, selling it is a problem because you need to talk. Then the main problem Maria has, no will. Then second will be just you're on the different laws. They're in the UK, so you've got one administration on one side and Spain on the other side. And then even selling that property is a nightmare. Because to be honest, it's hard for me to even say this, but it could take so much time that even children could be legal age. Because let's say if you're 12 years old, Michael, here, Pedro, and then 4 years fighting with the administration here, and you really need the money. So it's very important not to only just make a will. It is important to do the tax planning, but it is very important how, if the inevitable happens, how the executor is going to face the problem, whether at the time we will be able to sort it out, and whether it's viable, you see, because living, I think, is best. Correct me if I'm wrong, Michael and Pedro, probably better to make a legacy, saying with instructions, leave it to this person, that person, and send them money, or the executor transferring money, which is basically transferring money or living in our client account until his legal age, or into the parents or mother. But once you have children involved in property, to be honest, it's a completely nightmare, because getting paperwork to sell, I don't know if you did, Pedro or Michael, you had any recent case, but actually yes, I'm dealing with one now, and yeah. Completely honest, I'm blocked here. I'm pretty much stuck.
We've got one. We've got this case. They don't say what the age is. We did one last year, and in the end, we've recommended our client to try and rent it out and hold out for 6 years until the kid's 18 and sell, because the cost and the uncertainty of the procedure was just too much. And in the end, they decided that they could rent it out. So they've
that's good advice.
That situation is very difficult to resolve, because the judge at the end of the day wants to make sure that that minor's not cheated out of their money.
Yes.
And because the person's in the UK, it's very difficult to give the judge sufficient security that that money is going to be well looked after by the parents signing. So very difficult.
Michael, the protection is so high that it really takes the whole purpose of the will, because at the end of the day, the will was in goodwill. It was made to make life easier. But when you are not legal age, it is pretty much impossible to commit. I don't know if Pedro had something similar recently.
I may have misunderstood a little bit the question, but I mean this Hague Convention 1996, I think it doesn't work really on this case. I think this case is focused. It should be focused, as you are saying, Michael, is regarding an authorization by a judge in order to be able to be authorized in order to sell. You need to inform and have some big arguments in order, yes, to sell, be authorized. And the mother should be, as a mother, justify his mother and will be justified. She will be able to represent the child. Obviously, would be some mechanisms in order to be able to look for that the non-legal age child is not cheated, really. But obviously the timing and the authorization, going to court, this will take time, but at the end, in some way, we'll be able to be seen. About this convention that Maria is saying, which is regarding conflict of law, emancipation also is included in these cases. I would say that I think trust is, for example, we were speaking about trust is excluded, absolutely. But it could be in case that the child, in this case, for example, is 16 years old, they will be able to be chosen. But I think that we should be focused on a way that get authorization by the court in order to sell property, arguing that, the father has died, they live in the UK, the address in the UK, they don't decide they need to sell the property, and which is it's an argument in order to be authorized by the judge.
Mm-hmm. Okay, thank you, Pedro. We've got something I would like to answer to David Arnold. Is the first question he made. Obviously, it's only about tax planning, nothing to do with inheritance, but I would like to answer to him. It seems to me he sold his UK property in April 2021, and he owns outright a property in Murcia since 2016. I think he's quite confused because he's 72 and he thought before Brexit being exempt from capital gain tax. And then he's asking here that the following: did that capital gain tax criteria change for British relocating to Murcia? It appears that I cannot be a tax resident in Murcia in 2021, arriving late July. Okay, the answer to this, David, if you're moving from the UK to here and you sold it before, you are a no tax resident. And for selling as a non-tax resident in the UK, you don't need to do anything here. Now, you will be tax resident probably in 2021, and you will do your tax declaration in 2022. If you sold your property while you were non-resident in Spain, you don't need to do anything here, and it's nothing to do with the zero capital gain tax, nothing to do with Brexit. It's a matter of being resident and non-resident. You moving from the UK to Spain, you're non-resident while you sell, you already had a property here, and your question is whether you are going to pay on capital gain tax for selling while you are non-resident. And the answer is, while you're non-resident, you don't pay here. You only pay here when you are resident. And probably you're mixing here the information. For those who are selling in the UK or United States or anywhere in the world and reinvest it, they could just claim for the allowances, okay, for the reinvesting and capital gain tax zero if you reinvest the whole money on your main property. Certain requirements must comply, like being your permanent home when you sell, and you need to do invested money within the 2 years. Okay, but it doesn't apply to you, Dave. Okay, and obviously let's move on into the inheritance tax. Pedro, would you like to talk in this region? And I always say it's very hard to know to talk about tax, because we could be talking today about inheritance tax in Valencia, and tomorrow could be something completely different. I think, Michael, it did happen in the past to you and to us. We were a great place.
Yeah, absolutely. It's gone
the way, wasn't it? Yes, and suddenly we're a bit expensive then. And I wonder whether Pedro could discuss. Pedro, how does it work, the tax here in this region at the moment? Hopefully one day will be zero. But
let me just make a brief class. So, taxes in Spain are like three kinds of classes. It's like tasas. Contribución, tasas is like you receive a service, for example, you pay some delivery tax of, for example, university. And then contribución, for example, everyone has a property, you receive a service over the rubbish collection, you pay a small tax because of you are receiving a service. Then there's the third pillar, which is the most important pillar, which is the tax return and the inheritance tax. For example, or a value add tax, for example, impuestos indirectos, impuestos directos. So inheritance tax is I would say, it's complex tax and it's a progressive tax. As much as you receive or as much as you will pay. It's like a tax return, really, and it's direct. Okay, in Valencia region, let's say there are some deductions. This called like reducciones. It's like reductions. We have really reductions, and okay. I think Michael has said you have already said about this 100,000 euros is when you acquire as an inheritance some assets, and if you are older than 20 years old, I mean, as a spouse or descendants, then you will be that base will not be taxed. That is well, is one of the reductions that we have. And also another big reductions that we have is regarding if you're going to acquire some a house which is a permanent house of the deceased, which is adquisición vivienda habitual del causante, which is the reduction on that case is 95% with a limit of 150,000 euros. Okay. Always if someone who has lived in the property has been a minimum of 2 years. Okay, and what else we could say about this? I mean, this is two deductions: 100,000 euros, 150,000 euros. Oh, mainly it's good, important to know reductions in. It needs to be maintained if I have following years. Whoever is going to receive it, if you sell the property, imagine that you acquire the property as an inheritor, and then you want to sell it, you get its reductions, and you sell it in the following year, you will not be able to get these deductions. You will have to pay back whatever it should be paid. And what has been said about this timing is really 6 months voluntary period to apply for the inheritance tax. In case there is a complexity or you want to make an extension, you need to do it in the first 5 months in order to be extended another 6 months. The 𝐏𝐞𝐥𝐤 is a progressive, as I said, there is some scale, some percentage in order to be taxed according to the rest of the base to be taxed. And the 𝐏𝐞𝐥𝐤 is deducted 50%. So I always say mainly when someone is a couple has a property, let's say a value of 300,000 euros, which one of them between the spouses is going to receive the other half, which is valued in 150,000 euros. And imagine that they have like around, let's say 200,000 euros in cash. And at the end, will not be paying anything because he's receiving 150,000 euros of property, permanent property, if it's not sold in the following years, is a reduction of 100,000 euros. Also will not be taxed. So in many of the cases, I would say in most of the cases that we have clients with a property with some cash, which at the end the property is not a big value, like I would say no more than 300,000 euros, and cash in most of the occasions, I mean, they don't pay taxes at all. I mean, so I would like to eliminate all these rumors that saying that, well, you have to pay 30% or 40%. Well, in some ways, the tax could be high, like I would say included 34%, but there are some reductions on that. And we always recommend to make a planning, to make a study, to make a simulation in order to check what will be the taxes to be paid by the spouse alive, by the children that also have these benefits in order to receive. And there are right now many resolutions in Spain regarding if the deceased is resident or the beneficiaries are not residents, and in most of the ways are right now equivalent to someone which is resident or not resident in Spain. Even though when someone is not resident, then we have a different rule in Spain, which is a state tax for inheritance, which is slightly different, but in some ways has some these benefits in order to get a normal tax in order for the inheritance. But this is basically, Ignacio, is 100,000 euros reduction, and then 150,000 euros maximum for the property, permanent property. And I would say that in most ways, this reduce drastically the inheritance.
Okay, Pedro, thank you very much. I'm going to just take Paul's question, and then we're going to share with you, if one friend has available one video about inheritance tax that I think is worth you listening to it. Okay, as the final topics for you to learn. Now, Paul Francis is saying that his wife is Spanish national, Pedro. does her UK will still have precedence? Pedro, I think probably she made a will in the UK and she made a will in Spain. So I think we need more information, don't we? Because Spain will not take into consideration the UK will, at least for Spanish assets. There could be a conflict of wills. I mean, probably she did a will in the UK and she did one in Spain. Which one? One will be older, Pedro. The other one will be...
Yeah, that's right. Just to check, I haven't read the question, but it's regarding which is the last will, needs to be rejected, whoever is not the last will, and needs to be checked if between them are compatible, because it could happen that you can sign a will in the UK, you can sign another will in Spain and be compatible, one for the territory of the world, except Spain, and the other one just for the territory of Spain. What I think you've said is that the wife is in the UK and is Spanish national.
Yes.
I mean, right now, I mean, European law, I mean, as Spain in Europe, mostly all the laws that have been attracting to residency criteria, I mean, I understand that she's, what you've said is they are non-resident, even though she's a Spanish.
Okay.
So you make a will in the UK, as a priority, I would say, even though I need to study things, that UK law with the assets in the UK will be binding. But as non-resident with an asset in Spain and with the Spanish law, and this is what I understand is being asked. Obviously, she's not resident, she's a resident in the UK, and obviously the residency criteria is, or in this case, the domicile is connected with the UK, and priority will be the English law to be applied. And included for the assets, if has not been said anything about the Spanish assets, will be according to the UK law and will be with a will or with a probate or whatever. Okay.
Okay.
This is what I would say. But obviously, this when nationality and residency are mixed in this way with the Spanish, as you said at the beginning, I think that, I mean, Article 21 and 22, we could read it again, but I think we don't have enough time. But if you are resident in one country in Europe, and when I say not in the UK, not Ireland, not Denmark, they have not signed these regulations, but in Europe, you are attracted by the residence law, unless you choose your national law, that you could choose your national law.
Okay, thank you, Pedro. So as a final tip, some of you probably did make a will, some of you didn't make a will. If you didn't make a will, highly recommendation is to make a will. Even if it is simple, straightforward will, it will really help a lot of and put a lot of problems away. On the other hand, you could name the executor and you could make simples. You could control the tax planning. So it's very, very good. Very, very good. On the other hand, then not only the distribution of assets, just the tax, and naming executors saying, sell these, sell that, and do the other. I think is very important. If you didn't make any will, then it's time to make a will just for you, peace of mind. If you did a will, it is important for you to try to look into it to see whether it's sufficient, whether it's enough, whether probably you made some descriptions that are not going to make very easy and straightforward the probate. From my experience, Pedro, I think making a will is very, very important. If you make a simple will, even better. But even if it's not simple, make sure you could control it. When we do the appointments, we try to discuss the best way of distribution at the time of signing the will, the best way of distributing. Let's say it's better to split it into 3 equal shares because the allowances will eat up and you will not have any tax to pay. Probably that's not good in 10 years' time, and it's good to review it. Probably it's good to name an executor and you do not want to name it now, or you did name it and now you want to change it. Probably you already made a will in the UK, and as here Paul was saying, we need to see any potential conflicts. So my bottom line here, I did share with you, Pedro, if you could put your email here just in case somebody has a specific question that we could do a video conference or whatever is necessary. I did put here in the panel, and I will just share it with you again, an article where Pedro explains in our blog. Here you have, for you to read the article and even to watch the video. I think it's only 8 minutes, but I think it's good and refreshing, things that you need to take into consideration. Endurable power of attorney from husband to wife to husband is very important as well. It did solve a lot of problems, and even granting jointly with your solicitor. It will make things much easier. Okay, now we're running out of time, Pedro.
Okay.
Would you like to say anything else before we go?
Oh, just, yes, well, you said, I mean, make a will, have an appointment with your solicitor and study which is the situation about beneficiaries, about compatible wills between one country and Spain, about the investment that you've made in Spain, about the taxes. How does it work if someone dies? What would be paid the taxes, unless you are resident or not? I mean, will be paid some taxes in a different country and then deducted here in Spain or the other way. I mean, about conflicting conventions between, in order to avoid double taxation treaties. So these things need to be sorted out and checked perfectly. And I mean, why not think about that, study it and prevent it and sort it out perfectly and written in a will and according to the law that we have right now on taxes on inheritance. And that is something important to have done.
Okay, thank you very much. We'll leave you with Juanfran with one video, and then we will see you very soon with more updates in the law. Thank you for joining us, Pedro. Over to you, Juanfran.
Trust is vital when you're in another country. If you want to buy a home, set up business relationships, or apply for a residence permit, you need to be able to count on the best independent legal aid. Pellicer and Heredia is an international firm of lawyers with over 20 years' experience and one single aim: for you to live at ease in Spain. In order to give you a clear, streamlined, and fast response, we work with a cross-disciplinary team of professionals specializing in the main legal fields: civil law, foreigners' affairs, business law, tax and financial law, and international law. And to ensure that you're kept informed and up to date with everything, we have 6 offices on the Eastern Coast. Whether you're from here or abroad, we will always stand by you and speak your language. Our relationship is based on openness, professionalism, and a commitment to finding legal solutions in your best interests and for your peace of mind. Pellicer and Heredia, international lawyers.